unable to defend his or her home and family due to the lack of owning a large capacity magazine.
For me, every single day that this ban is in place, I know that it's saving lives.
A judge rejected a challenge to the state's high-capacity magazine ban, arguing that it is both reasonable and measured.
Case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past, we have to be ready for that.
And now live, this is not an absolute win for the gun advocates because the court in its ruling letting stand a provision of that controversial law.
Duncan versus Bonta is a highly consequential legal case that revolves around California's ban on large capacity mags, which are mags capable of holding more than 10 rounds of ammunition. This ban, enacted in response to several high-profile mass slayings, was challenged by various plaintiffs who argued that it violated their Second Amendment rights to keep and bear arms. The case was initially heard by District Court Judge Roger T. Benitez, who ruled in favor of the plaintiffs, declaring the ban unconstitutional. Judge Benitez reasoned that the ban burdened the rights of law-abiding citizens to possess arms and ammunition commonly used for self-defense. However, the state of California appealed the district court's decision to the United States Court of Appeals for the Ninth Circuit. A three-judge panel of the Ninth Circuit upheld Judge Benitez's ruling, concurring that the mag ban was unconstitutional. Despite this initial victory for the plaintiffs, the case took a dramatic turn when the Ninth Circuit granted en banc review, meaning it would be reheard by a larger panel of judges. In a surprising move, the en banc panel upheld California's mag ban, departing from the earlier rulings of the district court and the three-judge panel. Subsequently, the plaintiffs petitioned the U.S. Supreme Court to review the Ninth Circuit's decision. The Supreme Court agreed to hear the case and issued a landmark ruling in New York State Rifle and Pistol Association versus Bruin, which clarified the standard for reviewing Second Amendment challenges. In light of the Bruin decision, the Supreme Court vacated the Ninth Circuit's judgment in Duncan versus Bonta and remanded the case for further consideration. The implications of Duncan versus Bonta extend far beyond California, potentially impacting similar mag bans in other states. The case raises fundamental questions about the interpretation of the Second Amendment and the appropriate level of scrutiny to apply when evaluating arm control laws.
Unable to defend his or her home and family due to the lack of owning a large capacity magazine.
Well, I can tell you some other gun advocates are quick to come out this late hour calling this a big win in the fight for their constitutional rights.
This weekend makes it a felony to own high-capacity magazines that contain more than 10 rounds of ammunition.
A mass shooting event, it actually is 4 or more. So I don't know where he came up with the number of 10.
And now live, this is not an absolute win for the gun advocates because the court in its ruling letting stand a provision of that controversial law.
It also underscores broader debates about judicial activism, state regulation, and individual rights within the context of arm policy. As the legal proceedings continue to unfold, the outcome of Duncan versus Bonta will shape the contours of Second Amendment jurisprudence and arm policy in the U.S. for years to come. Legal battle over California's mag ban. The case of Duncan versus Bonta revolves around California's possession and purchase ban on so-called large-capacity mags, which are mags holding more than 10 rounds. The legal battle has seen significant developments, particularly following the Supreme Court's decision in Bruin. This paper delves into the intricacies of the case, analyzing the arguments presented by both sides and examining the implications of the Supreme Court's ruling on the Ninth Circuit's en banc panel's decision-making process. The legal dispute originated with Judge Roger T. Benitez's ruling that California's mag ban violated the Second Amendment. This decision led to Freedom Week in California, during which the ban was temporarily lifted, allowing residents to purchase high-capacity mags. However, the state appealed the decision to the Ninth Circuit Court of Appeals. In the Ninth Circuit, a three-judge panel upheld Judge Benitez's decision, concurring that the ban infringed upon Second Amendment rights. Yet the Ninth Circuit en banc panel, comprising 11 judges, later reversed this decision, affirming California's ban. This ruling was based on an interest-balancing approach that upheld the ban under intermediate scrutiny. The legal landscape shifted significantly with the Supreme Court's ruling in New York State Rifle and Pistol Association versus Bruin. The court rejected the Ninth Circuit's approach, emphasizing that the proper test for Second Amendment challenges is rooted in text and historical context, not tier-based scrutiny. Furthermore, the Supreme Court vacated and remanded the Duncan case back to the Ninth Circuit for reconsideration in light of the Bruen decision. Legal representatives for the pro-arm side, led by Michelle and Associates, contend that the Ninth Circuit en banc panel should uphold Judge Benitez's decision in light of the Bruen ruling.
So people have to come to a certain location and drop off their high capacity magazines.
For me, every single day that this ban is in place, I know that it's saving lives.
Says that we're allowed to keep and bear arms, and I mean, I think that there is a certain point where you have to be mature to own a gun.
Any potential problems, and we see them happening and occurring around the country on a regular basis with shootings.
Getting the latest on California's ban on high capacity magazines that an appeals court reinstated yesterday.
There's so many different things that can be done and should be done. And
they argue that the Supreme Court's rejection of intermediate scrutiny and its emphasis on text and historical context provide clear guidance for assessing Second Amendment challenges. Additionally, they assert that the en banc panel should not have jurisdiction over the case due to procedural irregularities, as highlighted by dissenting judges. The Bruen decision fundamentally altered the legal framework for evaluating Second Amendment cases. By rejecting tier-based scrutiny and emphasizing textual analysis, the Supreme Court clarified the proper approach for assessing arm control laws. This has significant implications for the Duncan case and similar challenges to arms regulations across the country. It underscores the importance of considering historical context and the original meaning of the Second Amendment. Oral arguments for the Duncan case are scheduled to take place on March 19th before the Ninth Circuit's en banc panel. These arguments will play a crucial role in determining the fate of California's mag ban. Despite skepticism about the panel's inclinations, the outcome of the case carries substantial implications for Second Amendment jurisprudence. It remains a contentious issue that could potentially lead to further review by the Supreme Court. The legal battle over California's mag ban, exemplified by the Duncan versus Bonta case, reflects broader debates surrounding Second Amendment rights and arms regulations. The Supreme Court's Bruen decision has reshaped the legal landscape, emphasizing textual analysis and historical context in assessing arm control laws. As the case heads back to the Ninth Circuit for reconsideration, the implications of the Bruen ruling loom large. The outcome of the Duncan case will not only impact California's arm laws, but also set precedent for future Second Amendment challenges nationwide.
I would say that the Attorney General does not know what he's talking about.
A judge rejected a challenge to the state's high-capacity magazine ban, arguing that it is both reasonable and measured.
And always fall back to the evidence that California has some of the strongest gun safety laws in the nation.
Mag ban mostly unblocked. A divided en banc U.S. appeals court granted California's emergency stay of a lower court decision that banned the state from executing its statute restricting the capacity of arm mags to 10 or fewer bullets. The U.S. Court of Appeals for the Ninth Circuit, voting 7-4, suspended the majority of a trial judge's ruling that would have put the state's large-capacity mag limit on hold beginning Tuesday. Accepted are portions of the lower court's ruling pertaining to mags legitimately bought and possessed prior to the judge's order granting a permanent injunction. The Ninth Circuit, which heard the case en banc on its own initiative, determined that Attorney General Rob Bonta was likely to succeed on the merits. The unsigned majority conclusion highlighted last year's landmark U.S. Supreme Court decision in New York State Rifle and Pistol Association, Inc. versus Bruen, which limited state limitations on where arm owners can take their arms. According to the court, California makes strong arguments that the law is consistent with the Second Amendment under Bruen. Notably, 10 additional federal district courts have addressed a Second Amendment challenge to large-capacity mag limits since Bruen's decision. However, only one of those courts, the Southern District of Illinois, issued a preliminary injunction, determining that the claim was likely to win on the merits, the panel stated.
it was not met with overwhelming support by many people that do own guns or believe in gun rights.
State Attorney General, along with other state lawmakers, say they are all reviewing the exact details of that court ruling.
Case to be brought to go in front of one of those judges and to have an outcome similar to what we've seen in the past, we have to be ready for that.
California cannot ban gun owners from having high-capacity gun magazines. A federal judge struck down the California law.
Large capacity magazines have historically, the data shows, been used in mass shootings.
The Attorney General has demonstrated that California will be irreparably harmed absent a stay pending appeal by producing evidence that large capacity mags pose severe hazards to public safety. If a stay is denied, California will undoubtedly see an infusion of large capacity mags, such as those employed in mass killings in California and abroad, the majority stated. Other interested parties will not be significantly harmed by a stay, which does not impede the public's right to purchase and possess a wide range of arms, as much ammunition as they want, and an unlimited number of mags carrying 10 rounds or fewer, the court stated. The majority ruled that the public interest tips in favor of a stay. The court stated in a footnote that the ruling granting a partial stay neither decides nor prejudges the merits of the appeal, which will be decided after full briefing and oral argument. Chief Judge Mary H. Murguia, Sidney R. Thomas, Susan P. Graber, Kim McLean Wardlaw, Richard A. Paez, Marcia S. Berzin, and Andrew D. Hertzwitz made up the majority. Chuck Michel, President and General Counsel for the California Rifle and Pistol Association, which represents plaintiff Virginia Duncan, said in a statement Wednesday that the group is disappointed with the court's use of irregular procedures and its misinterpretation of the Bruin ruling to temporarily stop this injunction from going into effect. However, we are certain that the Constitution and the Bruin decision will ultimately prevail. The CRPA will continue to protect arm owners' rights in California all the way to the Supreme Court. That's all for this video, folks. We'll see you next time.